Welcome to the Sentencing Reforms Training delivered by Marty Bernhout and Nick Ashby. We are both solicitors practicing at Legal Aid New South Wales in the indictable section. I'm Marty and Nick's with me. I've got a number of years' experience predominantly in indictable work, but also in some local court appearance work. And Nick has a broad range of experience both in New South Wales and in England, where he's originally from. This podcast is being recorded in September 2018, prior to the commencement of the New South Wales Government's sentencing reforms on the 24th of September 2018. We'd like to begin by acknowledging country. This is being recorded at our Central Sydney office of Legal Aid New South Wales. We acknowledge the Gadigal people of the Eora Nation. We pay respects to elders past, present and future, and acknowledge that the land on which we're recording this has been land that's been used for tens of thousands of years for learning and knowledge. The purpose of this podcast is for you, the listener, to gain a working knowledge of the New South Wales Government's sentencing reforms and to be able to appear in basic local court sentence proceedings after the reforms commence, which at this stage we anticipate will be on the 24th of September 2018, although that date is subject to final proclamation in the coming weeks. The first topic that we'd like to cover is the rationale for reform. This is an overview about some of the research and the evidence which the government relies on in having passed these reforms. The reforms primarily build on the New South Wales Law Reform Commission Report 139, published in July 2013. That report made a range of recommendations for reform across all areas of sentencing law. Not all of those recommendations have been adopted by the government in these legislative reforms, but that is where most of the recommendations that have been brought in have come from. You will see in the PowerPoint presentation which accompanies this podcast that there are a number of links where the type is in orange and is underlined. They are all hyperlinks, so if you click on those links, you'll be able to access the sources that they refer to. The other predominant research body that the government relies on in having passed these reforms is research conducted by the New South Wales Bureau of Crime Statistics and Research, also known as BOCSAR. They publish a substantial volume of research on the impact of a range of criminal justice issues, including sentencing options. The key documents or research papers that are used for these reforms are the papers on suspended sentences, published in 2010 and 2014, and the papers on intensive supervision in the form of intensive correction orders, or ICOs, which were published in 2013 and 2017. And again, you'll have access to those via the hyperlinks in the PowerPoint. By way of summary, instead of running you through each of those papers, there are three main topics that we think it's important for you to know before you dive into the content of the reforms. First, the research shows that suspended sentences have actually increased rates of imprisonment since they were reintroduced as a sentencing option in the year 2000. Secondly, that sentences of full-time imprisonment of less than 2 years, and particularly those sentences of 6 months or less, being fixed terms without a parole period, do not deter offenders from reoffending, and they do not reduce reoffending amongst those people. Finally, community-based sentences with intensive supervision and intervention, again in the form of an ICO, is highly effective in reducing reoffending, far more so than sentences of full-time imprisonment of those short periods. Our next topic is the reforms in a nutshell. This is a very brief overview of some of the key parts of the reforms. So the intention of the reforms, as stated by the government, is to reduce the number of short sentences of full-time imprisonment. Generally speaking, we're talking about less than 2 years, and particularly those fixed terms of 6 months or less. The reforms also aim to place more medium and high-risk offenders on tailored supervision rather than sending them to jail for short periods of time, because the research shows that intensive supervision for those offenders, being medium and high risk, has a far better impact on reducing reoffending than sending them to short-term prison sentences. The existing suite of community-based sentencing options, things like Section 10 and 9 bonds, as well as community service orders, are being replaced with a more flexible range of community-based sentencing options, with the key point being that the court is empowered to impose particular conditions which are relevant not only to the offending but also to the offender themselves. And finally, one of the big parts of the reforms is that the reforms remove some of the structural barriers to community-based sentences, especially the things that stop many offenders getting intensive correction orders and home detention in terms of their availability. The Act which is bringing in these amendments is called the Crimes Sentencing Procedure Amendment Sentencing Options Act 2017. You'll have the hyperlink to that. Once the reforms commence, they will simply form part of the Crimes Sentencing Procedure Act and the Crimes Administration of Sentences Act. Again, we anticipate that the reforms will commence on the 24th of September 2018. That's a Monday, but that date is subject to final proclamation. You will also see hyperlinks to the explanatory note, which is a guide to interpreting the legislation, as well as the second reading speech, which we think forms great significance in the overall intent of the reforms. You'll also see in the PowerPoint some abbreviations that helps you decipher some of the abbreviations we use throughout.
So, my name's Nick Ashby. Together with Marty, we've been delivering the training on the sentencing reforms over the last few weeks. The next topic that we want to talk about is the abolition of some existing sentencing options that we've all been using for a large number of years. So, in summary, the sentencing options that are being abolished are standalone home detention orders, standalone community service orders, the most commonly used good behaviour bond, that being Section 9 good behaviour bonds, Section 12 suspended sentences, and Section 10(1)(b) non-conviction discharge to comply with a good behaviour bond. So, just to repeat, those are the sentencing options that are being abolished on the 24th of September 2018 and will no longer be available. The sentencing options that will remain will include the following: a Section 10(1)(a), and that's Section 10(1)(a) of the Sentencing Act, a non-conviction dismissal; Section 10(1)(c), which is a rarely used but is a non-conviction discharge to participate in an intervention programme; Section 10(a), conviction with no further penalty. Fines are being retained, as are Section 11, deferrals of sentence for rehabilitation, sometimes known as Griffiths remands. Next topic: introduction of new sentence orders. So this is an introduction into initially the new community orders that will be available for the courts to impose on or after the 24th of September 2018. So the two new community orders are called, firstly, the Conditional Release Order, and we may refer to that as a CRO, just for ease of reference during the course of this podcast, and secondly, a Community Correction Order, or again we may use the acronym CCO during the course of this podcast. We have developed what we think to be the new sentencing hierarchy, and you will see this on a slide in the PowerPoint, and that essentially starts with a 10(1)(a) non-conviction disposal, 10(1)(c), and then we think the next level would be a CRO, a conditional release order without conviction, that being an order that may be imposed with or without conviction. More of that a bit later. Then a 10(a), conviction no further penalty, then a fine. Then we believe the next level would be a conditional release order, a CRO with a conviction. Then next a community correction order, a CCO. Then an intensive correction order, an ICO or ICO as it is known to community corrections. And finally the ultimate sanction of full-time imprisonment. Conditional release orders. So I'm going to talk a little bit about what those new orders entail. These are the lowest level community order. It is intended for a low level of offence It is similar to a 10(1)(b where it is imposed, to an existing 10(1)(b good behaviour bond where it is imposed without conviction. It is available for fine-only offences, and it is also available for offences punishable by imprisonment, obviously as an alternative to imprisonment. These orders can be up to 2 years in duration. As I have said, they are orders that may be imposed with or without conviction. So, for example, if you were representing a client on a low-range PCA and you were hoping to prevail upon the court to set a penalty that would not lead to the automatic disqualification, then a 10(1)(b conditional release order without conviction would probably be your sentencing vehicle. The orders cannot be imposed together with a fine for a single offence. They are direct alternatives. And these orders, and these are common features amongst both community orders, consist of 2 standard conditions, which are mandatory conditions, and they're similar in their terms to the existing conditions that apply automatically to a good behaviour bond, as well as then additional conditions. These are an exhaustive list of conditions which are set out in the legislation. There is some overlap between the 2 levels of community order. And then finally, the third tier of conditions available to the sentencing court are known as further conditions. These are conditions which are essentially anything you can think of. They are conditions that are at large. But as I say, the additional and further conditions are discretionary conditions that the court may or may not choose to impose. Community correction orders. So this is the second tier, the more serious tier of community orders that the court will have available for sentencing on the 24th of September 2000. Now, community correction orders are intended to be a more serious order than a conditional release order, but below an intensive correction order. So essentially the court would not be sentencing to a community correction order where the court has decided that the Section 5 custody threshold has been crossed. In those circumstances, the court would be looking either at full-time jail or an intensive correction order. The community correction orders, they adopt the elements of existing Section 9 and existing community service orders. These orders are available for offences that are punishable by imprisonment. They are not available for fine-only offences. The orders can last for up to 3 years, so for a very long period of time. These orders must follow a conviction. These orders cannot be imposed without conviction, and you can also couple these orders with a fine. So similar to the conditional release order, a community correction order will consist of 2 standard conditions, as well as additional and further conditions similar to the conditional release order, but there are other options available to the court when one looks at the list of additional conditions, those primarily being the availability of community service, which you could not have as a condition of a conditional release order, and up to 12 hours of curfew. Conditions of the new sentencing orders. So this really is grappling with the concept of 3 levels of conditions. So as I've said already, there being 2 standard conditions. These are conditions which are common to all community orders and intensive correction orders. The next tier are the exhaustive list of additional conditions which are set out in the legislation. And then finally the third tier of further conditions which are available at large to the sentencing court. So the standard conditions are found in what will be the new Crime Sentencing Procedure Act, Section 88 for community correction orders and 98 for conditional release orders. What you need to know are that these 2 standard conditions are mandatory. They are in force for the entire duration of the order, so for either up to a maximum of 2 years for a CRO or 3 years for a CCO. And the 2 standard conditions are, number 1, that the offender must not commit any offence. So that is a change from the historic standard condition of a good behaviour bond to be of good behaviour. And number 2, the offender must appear before the court if called upon to do so at any time during the term of the order. The next tier of additional conditions found in sections 89 for CCOs and 99 for CROs. These are a list of additional conditions which are exhaustive. They are conditions which are discretionary. The court can impose any of the additional conditions subject to limitations, and the court, and this is important, can limit the period during which the additional conditions are enforced. By that I mean that if, for example, the court imposed a 12-month conditional release order and decided that one of the additional conditions, for example, a prohibition to, place restriction order, place restriction condition, something of that nature, that could be a condition that could just be set for a proportion of the overall length of the community order. So if it was a 12-month order, then a place restriction order could be limited to, say, 3 months. The list of additional conditions, and I'll just quickly run through these, available on a community correction order only. You can have a curfew of up to 12 hours in any one day. Number 2, again, available on a community correction order only, community service. You cannot receive community service if your client is going to be made subject to a conditional release order, and the maximum duration of the maximum number of hours that can be set as part of a community correction order is up to 500. So that is a very large amount of community service available to the sentencing court. The other 5 additional conditions listed are common and available to both a conditional release order and a community correction order. Those are, to quickly list, rehabilitation or treatment, abstention from the consumption of drugs or alcohol, next, non-association with particular people or a particular person, next, a place restriction, perhaps not to go to, one example might be a particular shopping centre, and finally a condition to be subject to supervision by community corrections. We have provided you with a helpful one-slide table which essentially lists all the conditions that are available under CCOs and CROs. The table is also inclusive of intensive correction orders and sets out the slightly different list of additional conditions that are available to orders which represent jail being served in the community. We'll come back to that a bit later in this podcast. So further conditions, this is a slightly different concept than anything we have been used to in the past. These are referred to in sections 90 for CCOs and 99A for CROs, that's the Sentencing Act. These are entirely at the court's discretion. A court can impose any further conditions it deems appropriate. Essentially, they are at large, subject to them not being inconsistent with any of the standard or additional conditions, or, as we would suggest, good practice would be to make sure that any further conditions proposed to a sentencing court by a defence advocate certainly not be inconsistent with any existing civil orders, for example, AVOs or ADVOs. And as we've said already, the court can limit the period during which further conditions are in force. So it can be for the entire duration of the CCO or CRO, or simply for a proportion of that order. The court has a great deal of flexibility in how the court structures the period during which the various conditions are in force. So, for example, a community correction order could comprise a condition of supervision for the duration of the order. So if that order was 2 years in length, the court could set a supervision condition as an additional condition that would be binding on the offender for the duration of the order, but could also set an additional condition of a curfew. That would not be an electronically monitored curfew. It would be a requirement to live at a particular address during hours specified by the court, but that could be time limited. So, for example, that curfew could be limited to the first 3 or 6 months of the order. It's a punitive measure, and it may well be that as defence advocate you would be submitting that it will be proportionate to time limit that sort of onerous condition. Next topic, breach of CRO and CCOs. So community corrections now have statutory authority to address minor breaches of both conditional release orders and community correction orders without referring the breach to the court. I have to say that it is the court that retains the jurisdiction over dealing with breaches, but community correction officers are now going to be working on a policy basis within a regime that will hopefully mean that more minor breaches are not referred to the court for the court to consider its powers. If a breach is referred to the jurisdiction of the sentencing court, then the court would have the options to either take no action, could revoke or vary the conditions or impose further conditions. So essentially the court could set further conditions from the list of additional conditions within the existing order. So for example, a court establishing breach that is dealing with a community correction order under which the client is already subject to, for example, 100 hours community service, the court could add additional community service to the order as a way of dealing with the breach. Ultimately, the court has the power to revoke the order and then obviously could re-sentence to any of the sentencing options up to and including a term of imprisonment. Courts can also issue the same order multiple times with different conditions depending on the offence and the offender's personal circumstances. So there is no long stop limit on the length of time that a person can be subject to community orders. What this means is, for example, if a person was coming towards the end of an existing community correction order but appears on a new offence while subject to that community correction order, there is nothing whatsoever to prevent a court setting an entirely new community correction order, as I say, that could run up to 3 years in duration.
Next, we're going to talk about the changes to intensive correction orders, ICOs. So the legislation has introduced community safety as the new paramount consideration for the court when it's deciding whether to impose an ICO versus full-time imprisonment. One of the other big changes is that an ICO is now available for an aggregate sentence of up to 3 years. So that means if the court is sentencing a person to one sentence, an aggregate, for multiple offences, the ICO length can be up to 3 years. You still have the limit of up to 2 years for a single offence. Supervision is now a mandatory condition of an ICO, although that is in practice not different to what happens under existing ICOs. Really crucially, especially for complex needs clients, community service work is no longer a mandatory condition of an ICO. This means that even if a person is not able to participate in community service, that does not preclude them from getting an ICO. Now, instead of being a mandatory condition, community service work can be imposed as a discretionary condition if the person is eligible and suitable for that work, for up to 750 hours on an ICO. Contrast that with up to 500 hours for a CCO. As I think Nick mentioned earlier, detention has been abolished as a standalone sentencing option. It will now be incorporated as a discretionary condition, an optional condition of an ICO. So ICOs have the potential to be extremely punitive when you're looking at up to 750 hours of community service, as well as home detention and other punitive measures like electronic monitoring. The range of offence-based exclusions have been expanded beyond simply the prescribed sexual offences to an additional list of excluded offences such as murder, manslaughter and terrorism offences. ICOs are not available for offenders under the age of 18, and very importantly, there are new provisions that the court must look to when it's sentencing a person for a domestic violence offence, and in particular where the court is contemplating an ICO for that offence. Dealing first with this new paramount consideration of community safety. Well, what does that actually mean in practice? Section 66(2) tells you that the court must consider whether an ICO or full-time imprisonment is, quote, more likely to address the offender's risk of reoffending. And if you look to the second reading speech, which we think informs that assessment about ICO versus full-time imprisonment, you'll see the words from the Attorney General that community safety is not just about incarceration. Short-term prison sentences are often not the most effective tool for bringing about a reduction in reoffending. And we think you can rely on that in order to support a submission for an ICO as opposed to full-time jail in appropriate circumstances. As per CCOs and CROs, there are three categories of conditions for ICOs. You have standard, additional, and further conditions. The standard conditions are found in Section 73 of the Crimes Sentencing Procedure Act. Again, there are two conditions which are standard and they are mandatory, but those two conditions are slightly different to the two conditions for CROs or CCOs. So you've still got the first condition that the offender must not commit any offence, but you've got that different second condition of compulsory supervision, whereas supervision is optional or discretionary for a CRO or CCO. The additional conditions which are available for an ICO are set out in Section 73A. There are 8 additional conditions listed there. Again, that is an exhaustive list, and the court has the discretion to pick any or all of those additional conditions in a particular case. The only restrictions are that the court is required to impose at least one additional condition unless it finds that there are exceptional circumstances which justify the imposition of none of the additional conditions. And again, the court can time limit the period during which an additional condition is in force, meaning that a condition can be imposed for part of the sentence duration, not the full duration, if the court wants to do that. The list of additional conditions we've gone through earlier in respect of CROs and CCOs. It's a bigger list for ICOs because it's a more punitive sentencing option with a greater range of sentence conditions available. So you have home detention, electronic monitoring, a curfew anywhere up to and including 24 hours, which would essentially be home detention, community service work of up to 750 hours, rehabilitation or treatment, an abstention from drugs and or alcohol, non-association with a person or persons, and place restriction. So you'll note that some of those are the same as for CROs and CCOs, and some of them are only available for an ICO. The final category of condition for an ICO is the further conditions. These are found in Section 73B. Again, they are discretionary, at large, and they are not listed in the legislation. So the court can come up with whatever it wants, subject to the usual restrictions around enforceability. The Crimes Sentencing Procedure Regulation has not been proclaimed at the time of recording this podcast. However, we don't anticipate there being any changes, substantive changes to this aspect of the regulation in terms of community service work. So the regulation clause 14(1) sets out the maximum number of hours of community service work that the court can impose as an additional condition of a sentencing option based on the maximum penalty for a particular offence. So for an offence with a maximum penalty of up to 6 months jail, only 100 hours can be imposed. For an offence with a maximum penalty of between 6 and 12 months jail, the maximum number of hours of community service work is 200. For an offence with a maximum penalty of any more than 12 months imprisonment, the maximum number of hours is 500 for a CCO or 750 for an ICO. Clause 14(2) then sets out the relationship between the duration of the entire sentence order and the maximum number of hours of community service that can be imposed. And this just takes into account that offenders will need a sufficient amount of time to be able to complete their community service work if they're going to be able to comply reasonably with the order. So if you have a community service work component of up to 100 hours, the sentence duration must be at least 6 months. For between 1 and 300 hours, the order has to be 1 year in duration, 12 months. For between 3 and 500 hours, the sentence order must be at least 18 months. And then finally, for between 500 and 750 hours, which is only available on an ICO, not either of the other two, the order must be at least 2 years long. Now remember that the court doesn't reverse engineer the length of the sentence in order to allow time for the completion of the community service work. The court must decide the term of the sentence and then impose whatever it wants as up to the maximum number of allowable hours of community service for that duration of order. We mentioned earlier that home detention has been abolished as a standalone or discrete sentencing option. Instead, it will now be available as an additional discretionary condition of an ICO. We've been told by corrective services that, at least in theory, home detention is now available statewide. There is no requirement for the person to have a workable, viable landline for home detention to be imposed. There are existing offence-based exclusions which stop people from getting a home detention order as a standalone sentence. For instance, if the offender has ever been convicted of AOABH, they can never in the future get a home detention sentence. That has been removed, meaning that home detention will be able to be imposed as a condition of an ICO, regardless of what historically what offences the person has committed. Again, subject to the general exclusions around the types of offences which are excluded from an ICO. In the PowerPoint, we've set out the types of obligations which are inherent in a home detention condition. It's a very onerous order, and offenders need to be aware that they are required to be at home at all times otherwise than when they're approved to be away from home or when faced with immediate danger. Inherent in that is the requirement to submit to the community correction officer a schedule of proposed activities a week in advance. So that involves the offender telling their officer what they plan on doing over the next week and having that submitted for approval in advance. All offenders on a home detention condition will be subject to electronic monitoring. That is an inherent part of home detention. And community corrections have the power to make reasonable directions about electronic monitoring. For instance, where a person is and is not permitted to go. So things like exclusion zones. An electronic monitoring condition is slightly different. It does not require the offender to be at home under house arrest, essentially. Electronic monitoring is a different additional condition that's available on an ICO. It requires the offender, obviously, to submit to electronic monitoring, to comply with those reasonable directions of the community corrections officer, and then not to tamper with the equipment. It's less onerous than a home detention condition, and the reason we say that is because the offender does not have to submit a schedule of proposed activities for approval, in contrast to a home detention order. A curfew is another different type of additional condition. Court can impose a curfew of up to 12 hours on a CCO, or an unlimited or up to 24-hour curfew on an ICO. What a curfew requires is that the offender remain at home at all times within the hours specified by the condition. Again, there is no schedule of proposed activities, and this time there's also no electronic monitoring. I referred earlier to the range of excluded offences for an ICO being expanded. Those exclusions are found in section 67(1) and 2. You now have, in addition to the prescribed sexual offences, which are set out in subsection 2, you have murder and manslaughter, terrorism, and a range of offences involving serious crime prevention orders, public safety orders, contraventions of those types of orders. Section 4B is a new provision which provides restrictions on the imposition of ICOs for domestic violence offences. Subsection 1 says that the court cannot impose an ICO for a domestic violence offence unless the court is satisfied that the victim and any other person with whom the offender is likely to reside, for instance a family member, will be adequately protected. Subsection 2 provides that the court is not, in any circumstances, permitted to impose a home detention condition for a domestic violence offence if the offender is going to live with the victim of that offence. Next topic is breaches of ICOs. So the amended Crimes Administration of Sentences Act, section 163, provides clear legislative authority to community corrections officers to respond to lower level breaches of an ICO rather than referring every single breach to the parole authority to take action. So subsection 2 of section 163 sets out the range of actions that community corrections officers are permitted to take in respect of what they say is a breach of an ICO. So from least serious to most serious, you have record the breach and take no further action, give an informal warning to the offender, give a formal warning, meaning that telling the offender that further breaches will result in a referral to the parole authority, giving a reasonable direction relating to breach behaviour, or impose a curfew of up to 12 hours in any 24-hour period. So just to clarify, that is the only circumstance in which community corrections, without the involvement of either the court or the parole authority, can impose a further condition on an offender. If community corrections have taken less serious action than referring a breach to the parole authority, and the offender hasn't seen the light, or the alleged breach is too serious, or there are repeated breaches, the community corrections officer may decide to refer the breach to the parole authority. And similarly, if the offender wishes to contest a breach and says there was no breach, the offender can seek that the parole authority determine that issue. If a matter is referred to the parole authority, then you'll see in section 162 that the parole authority conducts an inquiry if it suspects that the offender has breached an ICO. That can occur even if the ICO has already finished or expired, and the offender is entitled to be heard in relation to that inquiry. Section 164 sets out the actions that the parole authority can take if it's satisfied that the offender has breached the ICO. So if you look in subsection 2, you'll see that it's not an automatic revocation of the ICO just because the offender breaches the ICO. Often, parole authority will act on a recommendation by community corrections, and that recommendation may be any one of a number of options, including to revoke, but also including things like taking no further action or giving a warning. So the range of things that the parole authority is entitled to do, in order again from least serious to most serious, are record the breach and take no further action, give a formal warning to the offender, impose any other conditions on the ICO, that is in addition to the ones the court imposed, vary or revoke any conditions of the ICO, including conditions imposed by the sentencing court, or finally, the most serious response is to revoke the ICO. I said a moment ago that the parole authority is entitled to impose conditions on the ICO. The sorts of conditions that the parole authority can impose are in subsection 3 of section 164, and they include imposing home detention for up to 30 days as a condition, or imposing an electronic monitoring condition. It's important to be clear that those are not things the parole authority does after revoking the ICO. They are potential remedies before the parole authority resorts to that ultimate sanction of revoking the ICO. Section 164 capital A sets out the process for the revocation of an ICO. If the parole authority makes that revocation order, a warrant is thereby issued and the offender would be taken into custody. The offender ordinarily is required to serve the remaining balance of their sentence in prison, because you will recall that at the time of sentence, when the court imposes an ICO, it is not empowered to impose a non-parole period. So whatever is remaining on the ICO, in theory, is what the offender is required to serve in custody. However, an ICO can be reinstated upon application by the offender. So section 165 sets out reinstatement of an ICO. So an offender must do at least 1 month in custody after the ICO is revoked before they can even file or make the application for the ICO to be reinstated. If the ICO reinstatement order is made, the offender is thereby released back into the community to serve the remaining balance of the sentence by way of ICO rather than full-time imprisonment. If the initial reinstatement application is unsuccessful, the offender is permitted to make further follow-up reinstatement applications every month until the end of their full-time sentence expires. The Legal Aid New South Wales Prisoners Legal Service, PLS, is a specialist service provided by Legal Aid. They deal exclusively with prisoners' matters, which includes advice, minor assistance and representation to prisoners, and the sorts of things they assist with include hearings at the Parole Authority for issues like revocation and reinstatement of an ICO. If you have any ICO-related questions, your best bet is to contact them via email at pls@legalaid.nsw.gov.au.
So next topic is changes to sentence assessment reports, this being the new name for what we used to call pre-sentence reports. This is now dealt with in the Criminal Sentencing Procedure Act, Division 4B. The community corrections officers writing the reports will provide information about the offender at the time of sentencing via, as I say, a sentence assessment report. Judicial officers, so magistrates and judges, can request a general assessment report which will advise the court on various sentencing options, or just for a particular type of condition, for example, home detention or community service work. Duty assessment reports, we understand, will still be available at certain courts as they are now. The matters that will be addressed in the reports are set out in the new Criminal Sentencing Procedure Regulation, Clause 12A, and those main matters that the reports will address will include the following: how an offender's behaviour and risk of reoffending would be addressed by supervision. That is a particularly key aspect of the reports, advising the courts in particular in relation to offenders who are assessed as medium to high risk of reoffending. Then any conditions that would facilitate effective supervision of the offender in the community, their suitability for community service if the court has so requested, a summary of the offender's response to any previous period of supervision, and any additional matters that the court wishes to have specifically addressed, for example, suitability for home detention. Reports are only required, they are only mandatory in a limited set of circumstances. So firstly, before imposing an intensive correction order, the court must have a report unless there is sufficient information before the court to justify the making of an intensive correction order without a report. These are found in Section 17D of the Sentencing Act. The second mandatory requirement for a sentencing assessment report to be commissioned is where the court is considering imposing a home detention condition as a condition of an intensive correction order. And there is one qualification before considering a home detention condition and ordering a report. The court will have to set the term of imprisonment, that is the length of the intensive correction order, before the court is allowed to for a home detention condition assessment. That will take 3 weeks. Then thirdly, the court is required to obtain an assessment report before imposing a community service work condition. We understand that could be a duty report in a straightforward matter, or it may need to be adjourned for an assessment report of either 3 or 6 weeks to be prepared. The procedure for imposing home detention is as follows. If the court is considering imposing home detention, it may, number one, refer the offender for an ICO assessment without setting the term of imprisonment. If the offender is suitable for an ICO, the court must then set the term of imprisonment, so that could be coming back after a 6-week adjournment, for example, and at that point the court would need to refer the offender for a further assessment in relation to home detention, i.e. to have the offender assessed as to whether the term of imprisonment set by the court may be served in the community by way of home detention. Or the second steps towards having a home detention assessment would be as follows. The court would set the term of imprisonment and then refer the offender for an ICO assessment, which would then include a home detention assessment. And what we would add is that whatever the entire duration of the ICO, for example, if the court has set a term of imprisonment of 12 months and the offender is assessed as a suitable candidate for that some or all of that sentence to be served in the community by way of home detention, the court need not set home detention for the entire duration of the ICO. So, for example, in a term of 12 months ICO, a term of 12 months jail served in the community by way of an ICO, the court could limit the period of time subject to a home detention, for example, to 3 or 6 months. Finally, the only other comment in relation to home detention is that the assessment having been undertaken, this is not necessarily binding on the court. Next topic, supervision. Now, Corrective Services New South Wales use an actuarial tool known as the Level of Service Inventory, revised, to assess an offender's risk of reoffending and identify their criminogenic needs. Not to get into too much of the detail, essentially this is an international tool originating, we understand, in Canada. The LSIR consists of 54 questions grouped into 10 topics and relies on principles of risk, needs and responsivity, that's RNR, which suggests the level of intensity of intervention for a particular offender, and that should be referable to their risk level. What we mean by that is that higher risk offenders should receive higher intensity interventions and low risk offenders should receive low intensity or no intervention. It is a fact revealed by the research that imposing supervision on low risk offenders can actually increase their risk of reoffending. Supervision obligations. These are found in the Crimes Administration of Sentences Regulation, clauses 187 and 188, and this sets out the offender's obligations if subject to a community-based sentence with a supervision condition. The key obligations are for an offender to report to community corrections as soon as practicable after an ICO is made, and certainly not later than 7 days after an order is made. If an ICO is made with an electronic monitoring condition, then the offender is required to report to community corrections the same day. Clearly, if this is an order that is made towards the end of the court day, there may be some logistical difficulties, and we understand that community corrections retain a limited discretion to allow an offender to report outside of those parameters, perhaps the following morning. The next obligation is for the offender to report as directed, then to comply with all reasonable directions of an officer, then to permit an officer to permit their place of residence at any time and to enter the premises for that purpose. We understand the intention there is not to police an offender's residence or their personal circumstances, but essentially community corrections, if they lose touch, wish to have the capacity to check how the offender is doing and in those circumstances visit them at their place of residence. And the final obligations under ICO supervision is for the offender not to leave New South Wales or Australia without prior approval. The obligations under community correction orders and conditional release order supervision are largely the same as supervision under an ICO. Next topic, suspension of certain conditions by community corrections officers. These are found in the Crimes Administration of Sentencing Act, Section 82A for ICOs, 107E for CCOs and 108E for CROs. Essentially, community correction officers can make an order suspending the application of a supervision condition on an indefinite basis, and separately an officer could suspend a curfew, non-association or place restriction condition, albeit not on an indefinite basis. So, for example, if your client wished to travel interstate while subject to a curfew, it may well be that following communication with his or her officer, the officer could unilaterally suspend a curfew or non-association or place restriction condition to allow such an event to take place. The suspension may be unconditional or subject to conditions, and it's important to note that community correction officers cannot suspend any other type of sentencing conditions. Suspension in those circumstances can only be done by the court if it's for a CRO or CCO, or the parole authority for an ICO.
Next topic is savings and transitional provisions. Next, what do we mean by that? Well, that's the new Part 29 of the Crime Sentencing Procedure Act, and savings and transitional provisions just refers to the way in which the existing legislation interacts with the new legislation and the transition from the old to the new. And in particular for practitioners' use, that legislation determines how existing and continuing sentences are going to be treated after the reforms commence on the 24th of September. Importantly, some existing sentence orders are, quote, taken to be, end quote, some other sentence order on commencement day. So we have interpreted that as some sentences being converted to a new type of sentence order, and the conversion is automatic. There's no requirement to go back to court or any other administrative body for the conversion to be certified. In the PowerPoint, we've included a table with the heading Existing and Converted Sentences. This sets out what happens to those existing sentencing orders. So if you're given a home detention order before the 24th of September, on the 24th, it will become this new form of ICO with a home detention condition in it. An existing ICO will become a new ICO. A community service order will be converted to a community correction order, CCO, with the community service condition inherent in it. A Section 9 bond will be converted to a CCO. A Section 10(1)B bond will be converted to a CRO without conviction. And the suspended sentence, an existing Section 12 bond, is the exception to the rule. A Section 12 bond will not be converted. It will remain in force unless and until the offender completes the order, or if they don't complete it and it's breached and the court revokes the order, the court will have to re-sentence the offender in accordance with the new legislation, meaning that home detention is not available as a standalone sentencing option, and the court only has two options, an ICO or full-time imprisonment. The provisions relating to appeals against existing sentence orders and bonds are found in Section 86, and this is important for offenders who are sentenced before the 24th of September, lodge an appeal which is not determined until after that date. So if the court hears an appeal from an order imposed before the 24th and it wants to re-sentence after the 24th, you'll recall that home detention orders and suspended sentences are no longer available. So if a person initially, at first instance, gets full-time imprisonment and the Court of Appeal finds that a Section 5 sentence of imprisonment is the only option, then the court can only sentence the person to an ICO, given that home detention and a suspended sentence will not be available. The other side is that if an offender is sentenced to full-time imprisonment prior to the reforms commencing, potentially because as a result of an ICO referral assessment, they were found to be unsuitable for an ICO due to ineligibility for community service. If their appeal is upheld, given that community service is no longer a mandatory condition of an ICO, they may be able to get an ICO on appeal, and then the appeal can be determined in that way. If the court refuses the appeal and confirms the original sentence order which was imposed, then the savings and transitional provisions apply. For instance, if you get a Section 9 bond before the 24th of September, you appeal, the appeal is refused, then after your appeal is refused, you will be on a CCO, not a Section 9 bond.
Next topic, applications to vary, revoke or add conditions to orders. The provisions are found in relation to community correction orders and conditional release orders in the Criminal Sentencing Procedure Act. That's for CCOs in sections 89 and 90 and for CROs in sections 99 and 99A. These applications are different to a breach hearing. There is no requirement for a breach to have arisen for an application to vary and order to be made. This is not by way of an appeal. The application is made to the sentencing court. It may be made either by the offender or by community corrections. There is no limit on the number of applications that can be made, but one qualification there is that the court may refuse to consider an application by an offender if satisfied that the application is without merit. When considering an application to vary, the court has the power to impose additional or further conditions, or to vary or revoke existing additional or further conditions of the CCO or CRO. The provisions are found in relation to community correction orders and conditional release orders in the Criminal Sentencing Procedure Act. That's for CCOs in sections 89 and 90, and for CROs in sections 99 and 99A. These applications are different to a breach hearing. There is no requirement for a breach to have arisen for an application to vary and order to be made. This is not by way of an appeal. The application is made to the sentencing court. It may be made either by the offender or by community corrections. There is no limit on the number of applications that can be made, but one qualification there is that the court may refuse to consider an application by an offender if satisfied that the application is without merit. When considering an application to vary, the court has the power to impose additional or further conditions, or to vary or revoke existing additional or further conditions of the CCO or CRO. Where we think variation applications are most likely to arise are where the circumstances of the offender have materially changed since the order was made, so that the offender was no longer able to comply with the existing order. For example, the offender has become injured and is no longer physically capable to undertake community service work. It may well be that variation applications may be made if an order has been made, but that certain information was not available to the sentencing court at the time that the order was made, that have frustrated the conditions imposed as one of those either community orders or as in the intensive correction order.
The final substantive topic of this podcast is the new provisions which have been introduced for the court to consider when sentencing for domestic violence offences. New Section 4A of the Crime Sentencing Procedure Act provides a so-called presumption of full-time imprisonment or supervision for all offenders found guilty of a domestic violence offence. A supervised order or an order with supervision means any of the community-based sentencing options with a supervision condition attached. That means a CRO, CCO or ICO with supervision. In theory, you can still have a CRO without conviction with a supervision condition attached and not fall foul of Section 4. The qualification to that presumption is that the court is not required to impose either full-time imprisonment or a supervised order if the court is satisfied that a different sentencing option is more appropriate in the circumstances. So generally speaking, the courts retain a fairly wide discretion to impose what they think is the most appropriate sentence in the circumstances of that domestic violence offence. Doesn't mean that all domestic violence offenders will be sent to jail or be supervised. The court still has the power to impose things like fines or unsupervised sentences, so a CCO or CRO without supervision, where that's appropriate. And you might think of cases where there are less serious types of offences or low-risk offenders, for instance, former flatmates who get into a blue and no longer have any contact with each other and there are no ongoing criminogenic needs. Another effect of Section 4A, we think, is that more medium and high-risk domestic violence offenders will be supervised and required to participate in programs which are aimed at reducing their risk of reoffending, rather than being given unsupervised sentencing options, which they're often given in the current regime, including Section 9 and Section 12 bonds without supervision. Section 4B provides a limitation that the court must observe in sentencing offenders for domestic violence offences. We referred to this earlier, but subsection 1 provides that the court cannot impose an ICO for a domestic violence offence unless it's satisfied that the victim and anyone else living with them, perhaps family members, quote, will be adequately protected. It seems to us that the standard of will be, as opposed to may be or could be, will be a fairly high bar for you to overcome as a defence advocate. Subsection 2 provides that the court is not permitted under any circumstances to impose a home detention condition for a domestic violence offender if the court believes that the offender is going to live with the victim. The test is a lower test for making a CCO or CRO. So an offender is still able to live with a victim of their offence if they're given a CCO or CRO for a domestic violence offence, but the court must still consider the safety of the victim before they impose the sentence. Final comments. Prior to the commencement of the reforms, again which we anticipate on the 24th of September 2018, we'll be creating a sentencing reform webpage on the Legal Aid New South Wales website. We expect that it will be located in the For Lawyers tab. That resource will give you access to all relevant materials, including a copy of an expanded PowerPoint presentation, as well as documents that we think will help you in the early stages of the reforms, access to the second reading speech and the legislation, a copy of other articles that we think might inform your work. If you have any questions or comments about the sentencing reforms, please feel free to email us. You can reach us at the Sentencing Reform General Inbox, which we check occasionally and which is monitored daily by our assistant. That is sentencing reform, one word, at legalaid.nsw.gov.au. Alternatively, Nick and I are both happy for you to contact us directly. My email is martin, MARTIN, .bernhout, BER for Roger, N for November, HAUT for Tom, at legalaid.nsw.gov.au, and Nicholas, NICHOLAS.ashby, ASHBY, at legalaid.nsw.gov.au.